guys. David Tarras, partner at the Rossen Law Firm and head of our federal criminal defense practice. We're continuing our series today on Paycheck Protection Program fraud, CARES Act fraud, essentially COVID-19 relief fraud, specifically as it relates to PPP. Now, what we're going to be talking about in this video today is ultimately one of the most crucial, if not the most crucial, stages in any federal criminal case, certainly in a PPP fraud case, which is the sentencing hearing itself. We can file the best motions, we can prepare your case unbelievably for trial, we can do the best possible job that any attorney can do for you at a trial, we can get you an amazing plea, but God forbid if you are found guilty at a trial, or you do ultimately decide with the counsel of your attorneys that entering into a plea deal is the best solution for your PPP fraud case, then ultimately we're going to go to a sentencing hearing. Now, in the federal system, sentencing is very unique. In state court, when you reach a plea deal with a prosecutor, if you've heard of this process before, or if you've been involved in this process before, you can reach a deal to a specific number of years. Let's say Joe Smith committed fraud in state court. Very commonly, you'll have a plea deal to 18 months of probation, to 2 years of prison, to 1 day in jail, whatever it might be. And usually the judge at that point is just a rubber stamp. The opposite is true in a federal sentencing, okay? Whether it's for PPP fraud, robbery, a sex crime, whatever it might be, the sentencing hearing is always going to be crucial. Because in the plea agreement itself, you can reach what is called joint recommendations with the government regarding the loss amount in your case, or regarding what guidelines should or should not apply at your sentencing, what enhancements should apply or not apply, what mitigating factors, such as having a small role in a conspiracy involving PPP fraud, or having a very low loss number or loss value in your case, what number should be applied. But ultimately, no matter what, even if the defense and the government are agreed on what the terms or what your plea should essentially look like, or what the number of months incarceration or of probation ideally look like, it's still only a recommendation in every federal case. At the end of the day, your case will go before a judge, and the judge can absolutely 100% reject not only the defense's recommendation regarding what your sentence should be, even if written in the plea deal, which there are ways to do that, okay, and some judges do accept that. They can still reject it. They can even reject the government's recommendation. So it is so crucial, especially in a fraud case, in a PPP fraud case, or complex white-collar crime in general, that you hire an attorney like myself and the attorneys at the Rossen Law Firm who have an immense amount of experience and understanding of the nuances of the federal sentencing structure, specifically as it relates to PPP fraud, and how these cases have been sentenced and litigated across the country. Because this is a relatively new area, because this program was not around for forever, as we know. So we're keeping a very close eye and a very close watch on the sentencing trends nationally and in our own local districts, which is the Southern District of Florida, although we do operate in all districts in the country and mostly throughout Florida. But Southern District of Florida is our home base. So when we're talking about a federal sentencing for a PPP fraud, in any federal sentencing, and certainly the same applies to PPP fraud, we're talking about, first and foremost, where is the law? What law are we following? What law is binding on us when determining your sentence? Now, in the federal system, there are two separate codes. There are two separate areas where we have to look when it comes to your sentencing, because this is where the judge is required to look. It's where the defense will argue, make their arguments through, the government will make their arguments, and the judge is bound by. One of these is the United States Sentencing Code. The other is the United States Sentencing Guidelines. Two related but separate standards, separate codes of law that directly reflect your sentencing. So the sentencing code The sentencing code sets the maximum term of imprisonment that you can face for any particular federal crime. In the context of PPP fraud, as we've discussed in prior videos, we're looking at very often wire fraud, bank fraud, false statements to a financial institution, identity theft, money laundering, very often involved. So for any of these crimes, the United States Sentencing Code is going to set what the maximum penalty is for that offense. For example, for wire fraud, 20 years, most commonly bank fraud, 30 years. Aggravated identity theft, an additional 2 years consecutive. The code says, here's what the max is, here's what your ceiling is. There are no minimum mandatory penalties, which is another concept for certain other offenses, such as drug trafficking and certain sex offenses. There are none that apply in the PPP fraud scenario, no matter how much money was involved. So we're really talking about setting the ceiling as far as the potential term of imprisonment, the potential term of any supervised release following a term of imprisonment or the federal version of probation, and also what the fine might be, or this cap or the ceiling on the fine. That's really what we deal with the sentencing code as far as the penalties. Then, we're dealing with the United States sentencing guidelines. The guidelines is essentially a point system, more or less. It's a point system. Every federal charge has a score, or it has a base offense level, we call it, or points attached to it. In a PPP fraud case, almost always, if we're talking about wire fraud, which is most common, or bank fraud, we're talking about really any charge that we're referring to in a PPP fraud scenario. We're talking about a base offense level of 7 points. Okay, so we start with 7 points on the guidelines. Then, the most important aspect by far of what your guideline sentence is going to look like is the amount of loss, the dollar amount associated with the PPP fraud, with this loan that our client may have requested, or that somebody else in certain scenarios requested for them, and that our client might have been involved with a conspiracy to commit fraud in that offense, or committed fraud in the way they spent the PPP Paycheck Protection Program money. The loss amount is everything in the sentencing guidelines. It is definitely the most, not everything, but the most crucial factor in any federal sentencing for PPP fraud. So we start with our base offense level, and then what we end up with when we add on the points for the loss amount, then there's certain enhancements that could apply. There's a very common enhancement called sophisticated means under the guidelines, where there could be 2 points added. Victims, not so common in a PPP fraud scenario. Ultimately, we're dealing with the base offense level of 7 and the loss amount value. When we're talking about loss amount in a PPP fraud case, the United States Sentencing Guidelines provides a table under 2B1.1. You don't have to memorize that, but that's the section of the guidelines, and it applies across the border for most fraud, theft, embezzlement type cases. So this table specifically correlates a dollar amount to an enhancement of your sentence, and it can vary. For example, for a crime that involved more than $150,000 but less than $250,000, the guidelines recommend adding 10 points to your offense level. For $550,000 to $1.5 million, in between that zone, you add 14 points. So you look at this table and you add the loss amount to your starting level, and then you result in a number that is pretty much where your guideline range is going to be at under the United States Sentencing Guidelines. Now, what happens next? If you've entered into a plea deal, you're very, very likely going to receive an automatic reduction for what's called acceptance of responsibility. If your points, after adding in any enhancements and reductions that apply under the guidelines, reductions being perhaps if you were involved in a conspiracy but had a minor or minimal role, you can, or your attorneys can negotiate to jointly recommend, or to recommend to the judge, or jointly recommend with the government to have between a 2 and 4 point reduction in your total offense level, this points that are ultimately calculated. But either way, your enhancements, your mitigators, we end up with a score. If you enter into a plea deal, if your points are 16 or above after taking everything else into consideration, the government is almost always going to recommend, and of course we would recommend to the judge, a reduction in 3 points from your ultimate level of your sentence. If it's below 16 points, it's going to be a reduction of 2 points for accepting responsibility. If you've entered into a plea, or even after trial, if you've shown remorse and acceptance of responsibility, if you're found guilty, you can still qualify for that. It's a bit more difficult, but we can do it, and it's definitely doable. So you'll get that reduction by entering into a plea. Ultimately, after taking into consideration the base offense level, the aggravators for the loss amount involved in the PPP fraud, in the loan amount, which is how they calculate it, the loss to the government, and then any enhancements and mitigators, we're going to end up with a number. This number is then going to be applied to a chart, to a matrix. And on the one hand, you have your number. On the other hand, you have your criminal history. If you have no criminal history or very minimal criminal history, you'll be in the first column. If you have minor criminal history or medium, you'll be probably the second or third column. At the end of the day, you match up your offense level, your points, with your criminal history, and you end up in this table with a guideline, with a range of sentencing. And what the sentencing code says, okay, now going back to the code, that the guidelines are advisory. They are not mandatory. They're a starting point, okay? When the sentencing hearing starts, the first thing that happens usually is the judge says, are there any disputes between the parties, including probation, about what the appropriate guideline level is that the court, that me, Mr. Judge or Mrs. Judge, should be applying in this case? Sometimes, often, we do not agree with the government or agree with United States probation on what the guideline is, and at the beginning of that sentencing hearing, we hash that out. The judge, first and foremost, has to determine what the appropriate guideline range is in your case, in your PPP fraud case, before moving to the next part of sentencing. So the guidelines are really a starting point, but they are a very, very important starting point in your case, because that's the first thing that happens at the sentencing hearing. Ultimately, after both sides present argument and the judge hears from United States probation, assuming there's no agreement or joint recommendation regarding your guidelines, the judge will, him or herself, make a ruling regarding what guideline level the judge is going to apply at your sentencing hearing. Then the judge has your guidelines, okay? The parties have your guidelines, so we know what we're dealing with the guidelines. The next phase is the judge turns to the sentencing code, which I told you before sets the ceiling, but it also has a very, very important section, USC 3553, 18 USC section 3553, which is everything to the defense attorney, because this is the section of the sentencing code that says, yes, the guidelines are a starting point, but it is just one of several factors that the court must consider when fashioning an appropriate sentence for our client. And this is where a great majority of our argument and presentation comes in. Yes, the guideline arguments are very important, but we're almost always arguing for a below guideline sentence at sentencing, which is what we call a variance from the guidelines, sometimes also known as a departure, depending on specifically what grounds you're asking for in a reduction. So this USC 3553, the 3553 factors are everything. And here are the 3553 factors. Factor number 1, the nature and circumstances of the offense and the history and characteristics of the defendant. 2, the need for the sentence imposed to reflect the seriousness of the offense, to promote respect for the law, and to provide just punishment for the offense. To provide adequate deterrence to criminal conduct, to protect the public from further crimes of the defendant, to provide the defendant with needed educational, vocational training, medical care, or other correctional treatment in most effective manner. 3, the kind of sentences available. 4, the guideline range, the kind of sentence in the sentencing range established by the guidelines, okay? 5, any pertinent policy statement, which is also related to the guidelines. 6, and very, very crucial in a PPP fraud case, the need to avoid unwarranted sentence disparities among defendants with similar records who have been found guilty of similar conduct. And 7, the need to provide restitution to any victims of the offense. So what our main job, what our main goal is at the sentencing hearing is to persuasively, effectively, and zealously argue why the 3553 sentencing factors that we just discussed, all of them perhaps that might apply, or we focus on certain ones depending on certain cases and what might be most persuasive for your individual case and your individual sentencing, why the judge should disregard, or not disregard the guidelines, but give the guidelines less weight, because the guidelines are usually very mathematical and are robotic and result in prison sentences, and focus instead on the human aspect of our client. And this is where 3553 comes in. The judge will look at the nature and circumstances of your offense. In a PPP fraud case, what do the judges consider here a lot? How did you spend the money? Okay, very, very common consideration. Did you buy a Lamborghini with the money, or did you pay off student loans, or did you pay off mortgage, or did you pay off a medical bill? Even though those are prohibited under the terms of the Paycheck Protection Program, it still is extremely important under these sentencing code factors for us to argue to the judge, look, this was not like our client was out there buying a yacht, buying a plane with this money. Listen, we can't control all of the facts in a case, so if that was the case, that's a situation where we focus on the other factors that are presented here. But the nature and circumstances of the offense and our client's role in the offense, if, for example, it's a conspiracy, but our client may have only given another individual permission to apply for a loan on their behalf and maybe not done enough due diligence, or had been reckless, or agreed to give a kickback of that money or pay a portion of the money to the individual who might have been applying for loans for many people. It's a common scenario we see. Then maybe we argue that you had a lesser role, even if you didn't qualify under the guidelines for a reduction. We would still argue it very strongly under the sentencing code under 3553 that we have discussed here. History of our client is huge. What have you done in your life that warrants the judge to look at our clients, to look at your specific case and say, this individual deserves a lighter sentence, this individual deserves mercy? We at the Rossen Law Firm do a massive, massive presentation as it relates to our clients' history and characteristics, okay? The human element of this, which cannot be avoided, because our clients are not just a number on a table or a matrix. You're a human being. You've had life experiences. You've had situations in your life, or are currently having situations where you might have made this decision out of necessity, not out of greed, and we need to present that, and we do regularly present that effectively to the judge. We'll also look at the accomplishments that you've achieved in your life. What education did you have, which goes both ways? What charitable organizations are you involved with? And what is your relationship to your community, to your family? Your medical status is very, very important. Your health, it's specifically listed in the sentencing code. So a lot of times we will get a very comprehensive medical background to present to the judge as to why you as an individual might deserve mercy or a lesser prison sentence, which of course can be very detrimental to your health. Unwarranted sentencing disparities, another very, very important aspect here. We're seeing for PPP fraud around the country a very wide range of sentences, okay? Federal sentencing, the purpose of the guidelines is to make federal sentencing, whether it happens in the Southern District of Florida or the Southern District of Texas, standard, based on your history, based on your role in the offense and the loss amount, essentially, are the considerations here. But we're still seeing a very large range. That's a good thing for defense attorneys, but can also be difficult. It just really depends on the judge you have in your district, and of course the quality of the attorney that you hire. Because we want to be able to argue, if favorable to us, what we'll do is say, okay, this is your guidelines, this was your loss amount. What we at the Rossen Law Firm will do is we'll go pull a whole series of cases around the country, and certainly with a focus on the Southern District of Florida, and specifically, if we can, with the judge you're in front of sentencing for, and find, okay, the best cases that match our sentencing, our circumstances, and say these are the lowest sentences. The court should, under the code, give a similarly low sentence because, like we said, the sentencing code specifically says the judge should avoid unwarranted sentencing disparities. And then we're talking about restitution to any potential victims. Not that common in a PPP fraud scenario as it is in some other forms of fraud. What we're dealing with, though, here is the amount of money that you might have already paid towards your loan can be very important in a PPP fraud sentencing. One thing to consider, and that we deal with because we're very experienced in this, is the judge will look to when you paid that money back. Did you pay it the day before sentencing, or did you start paying it back prior to ever being investigated or prior to being charged in your case? And we will present that to the judge. And there's different ways, if you hire us early enough, that we can structure that to make sure that you have the most effective sentencing outcome when it comes to any payments or lack of payments toward your loan, to make this financial institution, to make the United States government whole again. So lots and lots of different factors go into a sentencing for PPP fraud. We are extremely experienced here with this at the Rossen Law Firm. We know which arguments to make, which arguments not to make, and we start this process beginning from a very, very early stage in your case, simply because of the number, statistically, of cases that do resolve in the federal system with a plea agreement. We have to be prepared to put our best foot forward to make a comprehensive and beautiful presentation for you. So ultimately, at the end of the day, you have your freedom, you have the least amount of time spent either in custody or on probation or on house arrest, which are all possibilities and all outcomes in these cases. Our goal is to get you the least restrictive, because every day that you don't have your freedom is extremely, extremely important, not only to you, but to us as your attorneys as well. Okay, so federal sentencing in a PPP fraud case, you need to hire the Rossen Law Firm. We are experts in getting you the best possible outcome in this case.